Hi, I'm Scott Hetrick. I'm a partner with Adams & Reese in our Mobile office, and I've been practicing employment law for about 26 years, representing employers in dealing with the EEOC process, and have written responses to hundreds of EEOC charges. So I'm real excited to be talking with you today about the EEOC process and internal investigations and what an employer needs to be doing. And I'm really pleased to be joined by Suntrease-Maynard today.
Greetings. As my colleague said, I'm Suntrease Williams-Maynard. I'm special counsel also outside of the Mobile office. I just joined the firm this past March, right in the midst of COVID. A girl loves a challenge. Prior to joining the firm, I spent my career with the federal government. I was with the United States Department of Justice, specifically the U.S. Attorney's Office for a number of years, and then I moved over to the United States Equal Employment Opportunity Commission. So definitely excited to be here to talk with you about this. As I said, welcome to the Scott and Sunny Show. We're going to talk to you about what not to do when dealing with the EEOC.
All right, so Sunny, one of the things that's always kind of interested me as outside counsel for companies is what is the EEOC doing kind of behind the scenes before they even tell the employer that there is a complaint or a charge?
So Scott, at the very beginning, the EEOC is evaluating the charge of discrimination. I like to call this process the triage. And what I mean by that is EEOC is analyzing and assessing the charge of discrimination to determine whether it's going to be ripe or at least good for litigation, or if it will be eligible for mediation, or if it's a flat-out dismissal. So when they're looking at those things, when they're determining whether a charge may be, when I say ripe for litigation, is if it falls under the priority of the administration at that time. So they're looking at all of those things. In regards to mediation, that could be those cases where it could potentially litigate, where they're kind of on the fence about where the charge should be or where it should fall, because that too could also be litigated. And then, of course, those cases that come in, whether they're untimely filed, whether it's outside the jurisdiction of the EEOC, because when you're dealing with employees, a lot of times the first place they're going to come to complain is the EEOC. And a lot of people don't really understand the statutes that are enforced, so we're going to get some of those charges that are even outside of the purview. So at the very beginning, EEOC is really trying to assess where that charge should go. Then after that, the EEOC will schedule an intake interview, or maybe I should say the initial interview with the charging party. And Scott, what that is that investigator is meeting with the charging party to really get an understanding of the charge. What actually happened? What is the basis for the charge? Trying to get, the individuals that are involved, who the investigator needs to consider talking to. So really trying to get an assessment of what happened. So that's what's going on during that phase. And then, of course, they're going to have to notify the employer, right? EEOC is required to notify the employer within 10 days of the charge of discrimination. So that is what's really happening, where they're getting that assessment, they're talking with that charging party, trying to really get an understanding of where they're going to go with the case. And I think that the huge takeaway too is right at this phase, I've seen so many issues happen. So I think it's so good from the employer perspective is to really get your legal team on board early, because it's going to be a lot of things happening. The investigator is really going to get geared up, and I think you need to have your legal counsel on board to really be able to deal with the investigator. So, Scott, I've given you a little inside scoop about the EEOC and what they're doing when a charge of discrimination is filed. And you're going to have to give up a little bit of information and let us know what the employer's role is at this time.
Sure. So the biggest takeaway for employers, whether or not they're trying to handle a response internally, or having outside counsel assist them, is that they should not ignore the charge. This is the beginning of a legal process that could ultimately result in liability, possibly lawsuits being filed. Even if the employer won at the end of the road, oftentimes it could be a very long process, could be years to completely resolve if it's a complete scorched earth litigation. And you get off on the wrong foot if you ignore the EEOC. So one of the biggest determinations at the beginning is you need to begin your investigation very promptly once you receive a charge of discrimination, because that will help you either formulate your response or help you make a decision as to whether or not to engage in EEOC mediation like you talked about, because that's another kind of thing, is that sometimes mediation is offered and sometimes it's not.
That's correct.
And so if it is offered, then the employer definitely needs to think seriously about it and whether or not it would be valuable to discuss settlement with an EEOC neutral mediator. So begin the investigation promptly, and so there's a couple of things that the employer needs to be doing. So primarily, you want to gather information before you even interview witnesses. So you want to look at relevant documents, like what's in the personnel charge of the charging party, if there's comparators, people that were treated that were similarly situated but treated differently. Does the employer already have like an investigation notes file if they had an internal investigation of, say, a harassment claim? Or any kind of communications relating to the charge. Emails and text messages are often very important in charge. Like recently, I responded to a charge on part of a company that had a charge of sexual harassment against the employer. And as it turned out, the facts were that the charging party had actually quit her job with the employer, gotten another job at another company, and the harassment was happening at that job, not at my client's place of business. And I learned that, and I got valuable information, including text messages from the charging party to her former coworkers that helped prove that fact. So, and then another important thing is that you want to look at the relevant policy. So what are the rules that the employer has adopted for its own employees? And did the employer follow its own rules? Did the employee not follow the rules? Is that part of why the employment decision was made? You know, for example, if someone was fired for excessive absenteeism, you want to know and look at the absenteeism, the attendance, the tardiness policies. And then finally, you want to be able to interview all of the relevant witnesses. And so that's one, I think, advantage of having outside counsel investigate these things, is because that person comes in with kind of a fresh perspective. You're not talking to the decision maker. It's not the decision maker writing a response and being somewhat self-defensive. It's a person that is trained to write persuasively to the federal government, that's got experience doing it, can gather all this information together, you know, can be thorough, follow back. You know, I didn't learn about those text messages from the coworkers until I had gone back and re-interviewed, because one coworker mentioned something and I went back and talked to another coworker, and that's when they said, oh, well, here you go, I've got this text message. And so the ultimate goal, of course, is that you want to gather sufficient facts in order to fully respond to all of the major charge allegations. You want to be able to say to the EEOC, the charging party said X, here is our response to that. And these are the facts that support our position. All right, so moving on back to the EEOC, what is important to the EEOC? What are they going to be doing kind of like after they get the employer's charge? Or response, excuse me.
No, it's okay. So basically, after they've analyzed, right, and assessed a charge of discrimination, now we're going to be moving into an investigative phase for those charges that weren't discriminated. So one of the things that EEOC first considers is, what was the policy of that employer? They're going to want to know if someone had alleged, you know, retaliation. Do you have a no retaliation policy, you know, or an EEO policy of some sort? So that's going to be the first thing that EEOC is considering. So I tell employers all the time, you gotta have a policy. But you can't stop there. That's not enough for EEOC, because then the next thing they're going to want to know, Scott, is if the employees have been adequately trained on the policy. So when I was with the EEOC, that was an issue that would often come up. Right, well, we would get a policy, and then when we start interviewing the witnesses and we start talking to the employees, come to find out, you know, there is definitely a policy, but there was no training. Or if there was a training, it was very basic and generic during the onboarding process, and that's when the employees first hired. And then when we start asking the questions, come to find out, some would say, oh, well, onboarding was like 2 minutes. So, of course, EEOC's perspective is, well, what kind of training could take place in a matter of just 2 minutes? So I say to employers, you know, EEOC is going to want to know, did you train? And not just train adequately, but also how frequent, you know, is the training. It's one and you're done is not enough either. So one of the things that's really important is to try to have annual trainings on certain hot topics such as sexual harassment, the no retaliation, you know, those sorts of things. So that's so important. Also, when we're talking about training, and you know, we also look to see, or EEOC looks to see, whether there's separate training too for your managers and supervisors, because they should be trained at a different level. Now, they should receive the same training as all of the rest of the employees, but then they have a different, you know, level of responsibility. So they have to be trained on how to recognize these issues and how to respond to them. Also, they're speaking of, you know, supervisors and things of that nature. EEOC is going to wonder, how did the employer respond? right? When an employee came to them and brought them a complaint. Was that employer dismissive and just try to sweep it under the rug and say, oh, that's no big deal, or oh, Charlie wouldn't do such a thing, those sorts of things. Or, which the right way to respond would be prompt, right, and not sweep it under the rug and really take that issue head on and try to figure out what happened. So the EEOC is going to be looking at all of those things to determine if the response was appropriate. Also going into the investigative phase, of course, because this is your fact-finding time. So that investigator is going to be sending out RFIs. A lot of times an initial...
What are the RFIs?
Thank you, Scott. An RFI is a request for information. So at that time, some districts will send out a preliminary or an initial RFI when the employer is first noticed. And then, of course, you're going to get your more concrete RFIs as the investigation goes on. So then it's so important at that time, they're looking at different things. They're going to be asking about those policies. They're going to be asking for probably a roster of employees. They're going to more than likely, if attendance was an issue, be asking for some attendance records. So they're sending out these RFIs, and a lot of times I would see where your employer, want to challenge the EEOC, and that's okay, especially if there's a legitimate legal challenge, whether it's not relevant, if the request is too broad, but just a challenge for the sake of challenging is not very good, at least the conversations within the EEOC, because the perspective is, well, what are they trying to hide, right? So is there something that employer doesn't want the EEOC to discover? And ultimately, a lot of times too, and I had gotten into it with a counsel, a lot of people don't understand that EEOC does in fact have subpoena power. They can very well issue an administrative subpoena, and all that really ends up doing is delaying the investigation. And we all know that people already complain about how long these investigations can take anyway. So if you're doing that, and then of course with the administrative process, if the employee wants to argue that and file a petition, it just really slows things up. Also, during this investigative phase, the investigator will be conducting a series of interviews, right? We've talked to the charging party during that intake and some of those initial interviews. Now they're going to be trying to figure out who else may be relevant to interview, if there are other employees that may have information, also if there's management officials that need to be interviewed. And one of the things too, of course, from an employer's perspective, the employer can have a representative if there is a management or supervisory official being interviewed, but for those other non-management employees, the EEOC can go and talk to them. They don't need permission, nor do they have to provide that notice. So right now they're getting out there and trying to interview as many people as possible to see what they can find out. Also, during this time, your investigator may conduct an on-site visit. That's another thing, Scott, where a lot of employers are like, hands off, don't want to do it, don't want them to come. However, it can really be beneficial for that employer, because if you're thinking about the type of charge, for example, if it's an ADA, Americans with Disabilities Act, charge of discrimination, and that employee or that charging party has indicated that there's barriers to access, different things of that nature, an on-site visit can help that employer tell its side of the story to say, no, we've accommodated, look at what we've done, see this, EEOC investigator. So that can really be helpful with those on-site visits. And then it can also help too, because gathering those documents, I know it takes time. Employers is taking time away from getting the job done. It could be burdensome, all of those things. So an on-site visit, Scott, can also help alleviate that too, where the employer can just tell that investigator, you know what, just come on site. You can see the documents while you're here. You can interview, employees while you're here. So it can really help, because we want to help expedite things along, right? So they're doing that too. And then also in this phase, they're reviewing their documents, everything that they've gathered from the charging party, everything that they've gathered from the employer. Also, since I mentioned the ADA, usually there's with a disability involved, have to get medical records. If there was a failure to promote case, for instance, then of course getting resumes, looking at the job description so that the EEOC can assess, the qualifications to determine, who was in fact the most qualified. So basically gathering everything and looking at it and coming up with an analysis. So one of the things I want to say to employers at this point, I think it is so important from what I have had a chance to observe being on the inside, is to be cooperative. What's that saying, Scott? You get more bees with honey? Is that the saying? So I think it's like that. So you want to make sure you're having some of that honey, because you want to at least ensure that the investigator understands that you're trying to be cooperative, and you want to be thorough, because that's your time, that's the employer's time to tell its side of the story. You don't want the story to be one-sided. And I would often tell investigators, despite the fact that EEOC is a civil rights agency, at the end of the day, their job as investigators to fact find, to be neutral, to hear both sides of that story and really be able to come up with, an actual correct answer as it relates to discrimination. So once again, Scott, I'm giving you some inside scoop on what the EEOC was doing during the investigative fact-finding phase. Can you tell us a little bit about what should be an employer's response during this time?
Well, that's really valuable, and in fact, Sonny, that's basically sort of, doing this, like I say, I've responded to hundreds of charges over the last 25, 26 years, and so I've kind of learned what makes a good response. So mainly, I think that it's important to show that there is a fact-based, good, solid reason for why the employer did what it did. Because ultimately, most of EEOC charges that I've been dealing with are like something bad has happened to the employee. They've been fired. They've not been promoted. They've been demoted. And so they go and they complain to the EEOC, and they have come up with a reason in their own mind based upon their protected characteristic. The employer's job is to say, that's just not true. And here's the real story. And so when I write responses for employers, I generally follow this kind of format. I want to give a little bit of a background about the company, generally what do we do, what products do we produce, what services do we provide, who was the charging party, how they fit in there, were they a store clerk, were they the vice president of operations. I want to give the EEOC a very brief description at the very beginning of our cast of characters and how the charging party fits kind of in the chain of command. Again, if they're the vice president of operations, I definitely want to introduce who the CEO is, but I'm not necessarily going to be talking about the store clerks that weren't involved in this story. I want to tell who's involved. On the other hand, if it's the store clerk, I want to tell who are the other store clerks and the store manager, et cetera. I also like to include a couple of disclaimers at the beginning, not real elaborate, but essentially just saying, we're answering this based upon what we understand the allegations to be now and the facts that we've developed now. And we reserve the right to, if we discover something new, we're going to tell it to you, EEOC, or we're going to be talking about it later. We're not trying to hide anything, but we're giving you what we know now, and things can change on down the way. So the body and the main portion of the response should be really focused on, you take each major charge allegation and you respond to it. You give your side of the story, you cite to evidence, you cite to the emails, you cite to the documents in the personnel file, you cite to the policies, and you show, and if you're doing this in kind of a calm, reasonable manner, not attacking the person, but basically showing, unless there's a good factual base to do that, that these allegations just simply are not true, or if they are true, they're not really relevant. They don't prove anything. If somebody says I was hired on such and such a date, if you can show that they're not telling the truth, that might be interesting to say. But if they are, it's just drop a footnote that this fact is this is true. So at the end of the road, the response to the EEOC should be the employer's best statement of the actual facts, showing that race or sex or religion or the disability was in fact not the reason for the adverse job action, or that the individual may have been harassed, but the company responded in a reasonable manner and took prompt and effective remedial action. Because a lot of times, some of these harassment cases, they boil down to the charging party says that person, the harasser should have been fired. And that's not the law. It's just you have to take something that promptly, stops the harassment and is reasonable to believe that it's not going to happen again. And many times the employer doesn't fire the harasser, but they still win their EEOC charge because the response was legitimate. So now let's talk about what happens next. The EEOC has done that really elaborate investigation that you talked about. The employer has done a bang-up job on providing their response, and now we come to a phase. What does the determination phase, what does the EEOC do in there?
So at this point, Scott, now that they've done all of those things, they have to come up with a decision, right? Whether reasonable cause existed to say that discrimination in fact occurred. So two things could happen. They can find a no cause finding, which for employers like, yay, this is great, right? Because at the end of the day, then it was EEOC's decision that there was no reasonable cause. So therefore, they're dismissing the case, or the charge of discrimination rather, and then providing to the charging party a notice of right to sue. So at the end of the day, then that charging party can go ahead and go find an attorney, or unless they want to go pro se, and then they have 90 days on their own accord to file a lawsuit in federal court.
And I've seen a lot of those.
Yes.
Tell me about the other one.
So that's because you get those good responses.
That's true.
So, on the other side, where there won't be a celebration on behalf of the employer, is when the EEOC has determined that cause does exist, right? And so at that point, that's when the investigator will issue a letter of determination. That letter will outline their rationale as to why they feel like discrimination existed, and they will outline the evidence that was gathered to say, X, Y, and Z, this is what we've discovered, and this is why we've reached this conclusion. And usually with that letter of determination, they will offer will offer the party to come in and conciliate. And that's just an informal means of trying to resolve the situation, not to be confused with mediation, very different. Mediation, very quickly, if I may, is where actually dealing with the ADR program. EEOC has a separate and distinct division that handles mediation. So the cases are not mixed together. So it gets out of the investigative phase, whereas conciliation is handled by the investigator. It's still in that investigator phase. So that's when they're inviting the parties to come in and try to conciliate and resolve the issue, and they will provide a proposed conciliation agreement. That's where EEOC is outlining what it feels like the employer should do based on its findings. And then, of course, the goal is that the parties can come to some resolution, right, and that they resolve it. This is hopefully in the best interest of both the charging party and the employer. Like mediation, however, it is confidential. So at this phase, when the employer decides that, okay, we can reach an agreement, they can go on back to, operations, and no one would know outside of, those that may have been interviewed and involved, and that's it. Now, Scott, if conciliation, what EEOC calls failed, where they did not reach a resolution, now we're talking about potential litigation. And this is where things will get costly for the employer. So at this point, this is, when they're trying to decide too whether EEOC in fact is going to file the lawsuit, right? And then they will then, of course, not represent the charging party, but bring the case on behalf of the charging party. So they're going to be looking at if this is in the public interest, depending on what type of case it is, if they should in fact file suit or not. So that's pretty much, what EEOC is determining. And they're looking at everything, Scott, obviously, right? They're looking at what type of case it is. Once again, if it falls under the priorities of the administration, they're looking to see the complexity of the case, if it's a class of individuals that may have been potentially discriminated against. All those factors may very well make EEOC decide to go ahead and initiate the lawsuit on its own.
Right.
So all of those things. So that's pretty much what happens inside of the EEOC during the determination phase. Now, if you can tell us, Scott, what's the employer's next step if there's a cause versus
So if there's a cause finding, one thing that people may not understand is if there's a cause finding that is not 100% binding on the employer. They don't have to agree to conciliate. They don't have to settle. The EEOC is not imposing any kind of damages award. It's very different from say like the National Labor Relations Board, which can actually find you guilty and impose sanctions. So it's a little bit different. But the big thing is that the employer has to decide, do I want to cooperate with conciliation, which again, I tell employers all the time, it's just a fancy word for a settlement negotiation. And so your chances of, after a cause finding, there is a real possibility the EEOC could sue your company. And if the federal government with almost unlimited funds is suing you, you have a much more serious problem than if a charging party is suing you. So you have to look at those issues, kind of non-monetary issues, impacts on the company. Is it really going to be worth your time to engage in litigation? You know, it's going to take the decision makers away. They're going to have to be involved with lawyers. They're going to have to be going through depositions, et cetera. If it's not settled, those are the considerations to think about. Also, what is the other side asking? Is it something that you could pay now and avoid all those costs later on down the line? So that's kind of the considerations that are there. Now, the no cause finding, as she said, it's often a cause for celebration over on my side of the fence, because basically all you have to do is you get the no cause finding in and you just calendar their deadline. You know, when 90 days from the day I received it is presumed, the charging party is presumed to receive it 3 days after it's mailed by the EEOC. Just count ahead 90 days and that's the day marked. And because if they miss their deadline, they're out of luck. They can't sue under Title VII. You know, the only exception to that would be like a Section 1981 race claim, which has like a 4-year statute of limitations. But in my career, I could tell you, I've only seen one time when an African-American, I think it was an African-American, but of course it applies to every race, an African-American charging party completely missed the 90-day Title VII deadline, but they filed a 1981 claim about 8 or 9 months later. It's only happened one time in my career. So if you miss that 90-day deadline, my experience has been, the case is over. It's just not going to turn into a lawsuit. So I think we want to talk a little bit now about a couple of things that employers ought to be doing to maybe avoid getting a charge of discrimination from their employees, or at least reducing the chances of them, and certainly increasing the chances of winning if you get on down the road.
Scott, may I, before you go there, I
Sure.
chuckled earlier because it just makes me think about when I was with the U.S. Attorney's Office as well as the EEOC, defense attorneys always say the federal government has unlimited resources.
That's true.
And that's so not true. It is so funny because I remember,
Right.
I think, sorry EEOC, but I would have to get permission to get a pen, you know?
Yeah,
so,
that's true.
So I'm like, these resources are truly not unlimited, but I will tell you, they will pull the money in where it needs to be.
So if you're in the unlucky 1% of companies that get sued by the EEOC every year, let's listen to some of these tips. So the biggest thing, as we've already been talking about, is that you want to make sure that you have good, solid employment policies, you maintain them, and you uniformly enforce them. Don't treat employees differently, even for reasons that aren't related to Title VII, because those employees are going to think that's unfair that they're being treated, and they're going to go to the EEOC and complain. Another thing, of course, is that you want to make sure that you have good, solid hiring practices. Don't just hire anybody, because those people will probably be problems for you later on down the line. You know, I've had a lot of cases where the employers are talking to me about, we had to finally fire this person, and now they're accusing us of discrimination. You know, I wish we had never hired them in the first place. There was a bunch of red flags. So make sure you've got a good, solid hiring process to get good, solid employees from the beginning. Another issue is, as Sonny mentioned, and this is really across the board, is provide adequate training. And I don't just mean training with respect to compliance with like EEO laws, I mean across the board. Employees need to know how to do their job. And so they need to be trained on how to properly do their job, and you need to document that process. So then if they're not doing their job properly, you can point to, when you talk to the EEOC and tell your story, they were trained, they knew what to do. And then finally, I always recommend to client employers, use your evaluations process appropriately. Not just, you know, everybody's going to get a pay increase, and so we have to kind of go through and check all the boxes. Everybody gets 3s, you know, or you know, setting the stage for a termination. Effective performance evaluations can help poorly performing employees get better, and then those employees may not have to be fired, and so those employees aren't going to be filing charges over the fact that they were discharged. So, and then on the other hand, again, from the employment lawyer's perspective, is solid performance evaluations that state actual facts, why people are not getting as good ratings as others, are incredibly valuable information. I had a case involving a public utility, and this particular manager of engineers was incredibly detailed in how he described the charging party's poor job performance as well as comparators' good job performance. And I was able to show, look, here are actual facts in these records showing why this charging party, was not promoted and, ultimately was in a situation where she felt like she had to resign because her future was limited with the company. Sunny, do you have a couple of more tips for employers?
Absolutely. So you definitely want to address the problem or complaint when they arise. And we mentioned that earlier too. You definitely don't want to just ignore it or disregard it or come up with an excuse as to why to not tackle the issue at that moment. So you want to make sure the moment you have a complaint, so make sure you have a process in place with how your establishment handles any complaints that come in from employees. So that's definitely key. Also, you want to make sure.
You also would mean like a complaint by a manager about an employee not doing a good job. The company wants to respond to that promptly, right?
Correct. So when there's an internal complaint inside the workplace, you want to make sure you have a process in place on how to handle those complaints. And then when you do that, you also want to make sure you conduct a proper investigation of those complaints. So make sure that internal investigation is done so that you can document what you've done and that you were prompt in the response. Also, you want to make sure that you administer appropriate discipline when discipline and discharge is necessary. So do not just try to discipline because you think that it's just the way to do something. And one of the things I want to say too, I think it's so important that when you are making that decision, because there are going to be times where you're going to have to make the unpopular decision to discipline. But I always want to say you want to be cautious about taking those actions when there's a complaint filed, right? You want to kind of be very careful with the timing of discipline because you don't want that retaliation complaint to come. So just make sure that if you're doing discipline, if it's progressive, you're documenting that you may have talked to this employee before, that didn't work, and then you move to a written reprimand, those sorts of things. So consider also progressive discipline and just be appropriate in what you're doing. Also, you want to avoid character attacks. In evaluations and discipline, you got to make sure you focus on the facts. I always say, don't attack the person, attack the issue. So you want to make sure that you do not do that. It's not the time and place to do it. It's not the professional thing to do. So if you have an employee that is having issues, struggling in job performance, try to help that employee out, see if there's some remedial training, things of that nature that can be done. And then, of course, if things aren't working, then you properly notate it. But at least let's not engage in things of that nature that can be considered unprofessional. You also want to maintain good documentation of employment decisions. Document, I think is the best thing to say, and which is why Scott has been so successful too when he would tell his side of the story to EEOC, because then, as I mentioned earlier, if you have your policy in place, then you train, and then like Scott mentioned earlier too, if you document the training, have that agenda, have that signing sheet, all of those things, those documentation, that stuff could help you out. Even if you had to, reprimand that employee, you have that memo to file, just different things of that nature. So you just want to make sure that you're maintaining good documentation. I will say this, I know it may be a hassle up front to have to take that time to document, but I promise you, if you put the time in up front, it will save you time and money down the line when you have a charge of discrimination that has been filed. So I think that if you remember those tips, hopefully it will help you in addressing a charge of discrimination that's been filed with the EEOC. And I hope that you all got some really good pointers from the Scott and Sunny show. And Scott, I think that there are a couple of questions that we may have.
Yeah, so Sunny, we've got one question actually is, so this is actually something I'm interested in too. What is the trial attorney's role in all of the EEOC process?
It's so funny because I would hear that question a lot, and that was my role. I was a trial attorney with EEOC, and people think that I guess we don't really exist, but I say like that commercial, we really do exist and really do have a role in everything that we talked about, including going back to that assessment phase. When we're talking about the triage, every district is different, where some of the districts may have their director doing that triage process, some may have the regional attorney doing it, and some of the regional attorneys may delegate it to the trial attorney. But either way, that trial attorney is studying those charges that come in, because they are, in the whole process, giving the investigator directions and instructions on how to proceed. So when I told you about how we may have a case that may be good for litigation, that trial attorney is going to keep an eye on that charge. Also the ones that I told you that may be eligible for mediation, because as you know, not every case, not every charge will be offered mediation. The trial attorney is definitely keeping, his or her eyes on that one too. And they're going to guide that investigator on what they should be doing in the investigation. They're going to be, when the investigator actually calls the respondent or the respondent's representative, well, guess what, employers? This is why I say get your legal team on board early, because even though the employer is conversing with the investigator, that investigator is, conversing with his or her attorney. So they have their legal team on board early, and they're really directing it, because if they ultimately decide to litigate, that trial attorney has to be ready. So they're reviewing the RFIs, they're helping, formulate questions during the on-site, even though the trial attorney is not there. They're prepping that investigator for that on-site visit. When it comes to the documents, that trial attorney is assisting that investigator there too. So, the trial attorney is in the entire process serving as legal counsel to the investigator. So employers, make sure you have your guidance from your legal counsel as well. And then, of course, if the case is litigated, the discovery, the trial attorney, of course, is present. That's when we become visible to the general public.
All right.
So I hope that answered your question,
It did.
Scott.
I think we've got some more questions.
Yes, we do. And as a matter of fact, if you can tell us, Scott, what should an employer consider before making a significant employment decision, such as a discharge, or reduce the risk of a charge?
Okay. Yeah, that's a really good question, and that's something I'm involved in all the time on kind of day-to-day counseling on employment decisions. I think it's helpful before an employer makes a discharge decision that they think might be risky, is just to talk about it with somebody. If you're a big enough company, you've got an internal HR department, your manager should not just be firing off the hip. So they probably need to talk about it with somebody internally. If they're fortunate enough to have employment counsel, call them up and just bounce it off of them. I get calls like that all the time. And a lot of times, at the end of the call, it's typically, I think the discharge that you're contemplating is defensible, because that's always my perspective. Not, are you making a good business decision? I may think it's a terrible business decision for them to fire someone. It's from a legal perspective. Have you done enough homework? Do you have enough, do you have the dirt on the employee? Have you done progressive discipline? Have you treated other employees the same? Do you fire other people for this same conduct? And so, going through at least a process of, stress testing the decision before you actually pull the trigger, I think is a good one. We have any more questions?
I think so. I think I see some coming up.
So here's a question coming up. This is one for you. What is the best way to communicate with the EEOC, during this investigation process, during a process of having a charge kind of active? So,
Scott, good question also. It's always best, and I think this has been the recurring theme throughout our talk today, is to, one, be prompt, right? So when the EEOC is reaching out to the employer or the respondent's representative, it's so important that you're prompt with your responses and not to just kind of kick the EEOC to the side. Also, it's very important to be respectful and courteous and professional, in your dealings with the EEOC. Once again, I cannot overly emphasize the importance of really trying to have that positive relationship with the EEOC, especially the large employers. With all due respect, regardless of what the employer is doing to be a model workplace, as long as you have employees, there are going to be complaints. So you're going to be dealing with that same office.
Right.
And so that's going to be a relationship that really should be developed in the right way. And one of the things that you will find too is that that investigator will help you if you create that right relationship, and will make sure that you stay abreast of where the charge is, where the investigation is going, because you want to have that open communication. And it's okay, not just for the charging party, but it's okay for the employer side, the respondent's representative, to also pick up the phone and inquire from the investigator,
Right.
what are some of those next steps. You want to be able to do that, because
Right.
guess what, when you get into that phase, if they found cause, you have to go into conciliation. And I've had one of these issues actually since I've been with the firm, is trying to get an assessment of damages, because there's a host of remedies that they could try to get during that conciliation phase, injunctive relief, all those things. And if you have that open communication, you can get that investigator, like, let's talk about these monetary damages. How did you get to this calculation?
Right.
Where are we getting this from? So I think that if you're prompt, you're respectful, you're courteous, that's definitely some of the best ways to communicate. And pick up that phone and email, whatever your best way of communicating with that investigator. Just keep that communication open.
Well, let me toss in my one cynical defense lawyer's comment. If you talk to an EEOC investigator on the phone, follow up with an email just to confirm what you talked about.
Absolutely. And I think that goes both sides, because guess what? Within EEOC, the trial attorney will tell that investigator to do the same thing.
Yeah.
And sometimes we may draft the email, you
Right.
just don't know before they hit
Right.
send. So absolutely, it's just about still relationship building, right? So even those we trust, we memorialize.
All
a
right.
lot
Do we
of
have any
times.
more questions from our audience?
I think so. There's one coming in. That one's for you, Scott.
Oh, okay.
When should an employer conduct an internal investigation?
That's a pretty good question. Obviously, it's going to depend upon the circumstances and the nature of what's being investigated. For sure, if you get an allegation of harassment or discrimination or retaliation of any kind, so that then, of course, we have to step back a step. The employer needs to have a good, solid policy to tell employees what to do, who to go to. Specifically identify certain job titles, locations, etc. Go and complain if you think you've been harassed, sexually, racially, what have you. That's definitely a time to conduct an internal investigation. The other time to conduct an internal investigation generally relates to kind of serious misconduct that might have ramifications beyond the employment context. So if money comes up missing, if you're at a really big company, like a publicly traded company, if there might be some sort of situation involving insider stock trading, that comes to mind, you definitely want to be able to do that. So it's going to depend upon the circumstances. For the most part, if it's one of those things where it's not open and shut, you look at attendance records and it's clear this individual has breached your attendance expectations. Not much of an investigation there. On the other hand, if something bad has happened to your company and you haven't got anybody red-handed, you may have to conduct an internal investigation and talk to all the people potentially involved as your witnesses in order to come up with, what is my decision? What am I going to do with this scenario? Is someone going to be fired because the door to the store was left open and all this merchandise happened to just walk out over the weekend?
Grew legs.
Yeah, exactly. So that looks like it's all the questions we have from our audience.
Scott, if I may add something to that too, I think it's so important when you're talking about internal investigations for employers to have a good reporting process in place. And I say that to say, depending on the size of the employer, of course, but hotlines may be a good way, because you have to be mindful. I know that I had a case with the EEOC, and it was this fast food restaurant that employed a lot of high school students. And the way they had the reporting, I think it was way up to some district manager where these, young folk would never encounter this person. So when you make the reporting process that challenging,
right,
EEOC will find that to be problematic. So you want to make sure that you're looking at your reporting process so that things can be investigated,
right,
and have more than one person as a point of contact for those things. So just keep in mind and assess that.
Well, that's all the time we have. Hopefully some of this information was helpful to you today, and I really appreciated you working with me on this, Sunny.
Thank you, Scott. The pleasure was all mine. Thank you all as well.